to kind of give you a little bit of an overview of today's presentation, we'll talk about what you should and shouldn't do when protecting your assets. We'll give a breakdown of trust basics. We'll talk about the different types of trusts, the revocable, the irrevocable, the Spendthrift, the ILIT. We'll talk about the definition of the Domestic Asset Protection Trust, which a lot of people have probably heard or been referred to as the DAPT. We'll go over a bunch of reasons why the DAPT is not so great for asset protection, and we'll even touch briefly on the International Trust, which could be a better and safer alternative. So to get started, what is asset protection? And people give a lot of definitions of asset protection. The definition that I give for asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors. And I'll repeat that because it's a long definition. The definition that I give for asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors. And a lot of people say, well, do I have enough assets to protect? And the short answer is yes. Everybody needs some sort of asset protection. In fact, I argue that the less you have, the more you need the protection. And I always like to give this example. We represent a lot of professional athletes, NFL players, NBA players, and take one of my football NFL guys who signs for $50 million. Well, if he's sued for $5 million, he's not going to be happy, but he still has $45 million left. Take the average Joe who saved up his entire life, maybe he's retired, saved up a couple $100,000. Well, if he's sued for $1 million, he's going to be totally wiped out, catastrophic, no coming back from that. So my argument is the less you have, the more you need protection. Now, obviously, we're not going to do it to the same degree. And a lot of people say, well, what if I already have an asset protection plan? And if you do, I think that's great. But you want to have it checked on. Just like you get an annual physical every year, you should have a financial physical every year. Assets change. Laws change. Always make sure that your plan is up to date and that you're protecting every asset from everyone every time. A lot of people say, well, why do I need asset protection? And I find this little cute cartoon in the right-hand corner. It's two lawyers, one saying, I say sue. The other one says, anyone in particular. And I always get a few laughs when I show this, but unfortunately, it's not funny. Just like you guys are smart enough to get together today and, try and learn from an asset protection point of view, well, the lawyers get together, but they don't get together once a month like us. They get together once a week or once a day, and they're trying to figure out who are we going to sue next. The doctors, the business owners, who's going to be our next target. There's over 100 million lawsuits every single year, and that number is only growing. In today's bad economy, people are losing their jobs. The people who are lucky enough to keep their jobs are making less and less. Why not go to almost any single corner, find an attorney, don't even have to pay him because the attorney will probably take your case for free on a contingency fee, and sue somebody. You invested maybe 20 or 30 minutes of your time, and if you win, a lot of time it's tax-free money. There's a 1 in 4 chance you will be sued in the next year, and the average person and company is sued 5 times over their lifetime. So if you have an LLC or an S-Corp, on average you're sued 5 times over your lifetime. On average, your business is sued 5 times over your lifetime. Now, these are just the stats. There's a 50% chance of divorce, and a lawsuit can cost you tens of thousands of dollars even if you win the case. And I always like to talk about this because in today's society, they make it so easy, so inexpensive, if not free, to sue somebody, but they make it so difficult and expensive to defend yourself. So even if it's a frivolous lawsuit, even if you're right, it could still cost you tens or hundreds of thousands of dollars just to defend yourself. So I tell my clients the trick is not making money, it's keeping it. For every 60 minutes you spend making money, spend 60 seconds thinking about how to protect it. Well, a lot of people say, what about liability insurance? Isn't that enough? And I tell my clients to buy as much insurance as they can because it's cheap and it helps them sleep at night. But you always have to remember that 70% of lawsuits are not covered by insurance. Insurance companies are for-profit companies, and they make a lot of money. They're usually the ones off the highway with the big buildings with their names on it. Their goal is to take in as much premium as possible and pay out as little claim as possible. My father once told me, the big print giveth, the small print taketh away. In an insurance policy, there's usually about a half a page of what's covered and multiple pages of what's excluded. Your coverage may be inadequate. You may have $100,000 of coverage on your car, or $250. Well, what happens if you hit somebody and paralyze them and you get sued for $1 million? Who do you think has to come out of pocket for the difference? Your insurance company might go bankrupt. Now, if I told you that years ago, you probably would have hung up the phone. But in today's day and age, we have banks going out of business, Fortune 500 companies going out of business. Who's to say the insurance companies won't be next? And insurance doesn't cover other uninsured financial risks and divorce. And actually, there is a company out there now that offers divorce insurance, so who knows what will be next. Insurance alone is not the answer. You need your own asset protection plan to supplement your insurance. You want as many layers, as many firewalls, as many speed bumps between your assets and the creditor as possible. I call it the belt and suspenders approach. So 3 maxims of asset protection. Number 1, you got to protect yourself before you have a problem. I never understood why this was so difficult. You can't buy car insurance after the accident. You can't buy health insurance after you get sick. You can't buy life insurance after you die. You got to be proactive and put your asset protection plan together before you get sued, before you have liabilities. You want to start with a basic plan and add firewalls as needed. I can't tell you how many times someone will read one of my books and call me up and think they need some big, expensive, complicated plan. Start very simple. As your assets grow, your plan can grow. As your education grows, your plan can grow. And most importantly, don't look for one magic bullet or one right plan. Asset protection should not be done in a cookie-cutter fashion. Everything we do is individualized and customized and tailored for the clients. Everybody's personal assets are different. Everybody's business assets are different. And everybody's potential threats and creditors are different. So what might work for you might not work for me, and vice versa. A lot of mistakes to avoid, but the 5 killer mistakes to avoid. Number 1, hiding your assets. Asset protection is not about hiding. It's not about secrecy. It's about protection. In fact, I tell every one of my clients to assume that at some point they're going to have to disclose where their assets are. Because if they get sued and they get sit down and then they lose and they get sit down for a financial deposition under oath, and they're asked what assets they have, they're going to have to tell the truth. And if they don't tell the truth, they're going to be perjuring themselves. So an asset protection plan that's good should never deal with hiding. You should be able to tell everybody what you have and where it is. They just shouldn't be able to get to it. You never want to title your assets to straws. I can't tell you how many times someone will call me up and say, "Oh, Mr. Presser, I'm being sued, but I gave everything to my brother-in-law or my best friend." What actually makes you think that your brother-in-law or best friend has less financial problems than you? I've seen times before where a client gives the assets to his brother-in-law, the brother-in-law gets sued, and the creditor takes his assets. I've seen times before where the client gives his assets to the best friend gets divorced, and the wife takes his assets. So you don't want to go titling all your assets to straws. You also don't want to title all your assets to your spouse. We see this a lot with our doctor and physician and surgeon clients. They say, "Oh, don't worry, Mr. Presser, everything's in my wife's name and I'm okay." Nobody's immune from a lawsuit. Your wife can just as easily get in a car accident taking the kids to soccer practice. Nobody gets up in the morning and expects to be sued. Committing fraudulent transfers. This is when you try and protect yourself after you've been sued, and you never want to do that. As we talked about before, you want to do proactive planning because that's the type of planning that works. And of course, you never want to break any laws. Our law firm does both domestic and international asset protection. There's nothing wrong with having offshore accounts and offshore banks and offshore trusts and offshore companies, but there is something very wrong with having them and not disclosing them to the proper officials. So no matter what you're doing, domestic or international, you need to make sure you're filling out all the proper reporting requirements with the IRS, the Treasury Department, etc. So let's talk about trust basics. What is a trust in general? And the trust is where a settlor or a grantor, that's the name of the person who starts the trust. Some people say settlor, some people say grantor, but it's the person who starts the trust. They create a trust, and they put some sort of asset in the trust. It might be real estate, it might be money, it could be anything. Some sort of asset goes to the trust. There's a trustee, and that trustee holds the legal title of that asset. So the trustee technically owns legal title to the asset, and they're owning it on behalf of a beneficiary or beneficiaries, which is whoever is going to benefit from the trust. So in any trust, you have the person who starts the trust, which is the settlor or grantor. That settlor or grantor puts some sort of asset in the trust. You always have a trustee. The trustee is the one who owns legal title to that asset and watches over it. And the trustee's watching over it on behalf of the beneficiaries. And those are the people who benefit from the trust. So you might be a settlor or a grantor. You might put money or real estate into the trust. You might appoint one of your friends or attorneys a trustee. And you might name your kids as beneficiaries. They're all customizable, so you do it any way you want. There's two types of trust. There's a revocable trust and there's an irrevocable trust. And it's actually quite simple. The revocable trust, if you put an asset into the trust, you can take it out at any time. It's revocable. The irrevocable trust, once you put an asset in the trust, you can never take it out. It's irrevocable. And probably the biggest misconception that I see in my office is that when people come in with a trust already done, 99.9% of them have a revocable trust. Sometimes it's referred to as a living trust or a domestic revocable living trust. And it's great that they have these trusts because it's great for estate planning. But the revocable trust, the living trust, won't give you any asset protection. And if you think about it, it's common sense. It's revocable, which means you can take the asset out of it. So if you can take the asset out of it, the judge can make you take the asset out of it. There's also both domestic and international trusts. And domestic trusts simply mean inside the United States. International trusts simply mean outside the United States. And that's really the 5-minute overview on how any trust works. Any trust has a settlor or a grantor. Every trust has a trustee. Every trust has beneficiaries. Every trust is either domestic or international. And every trust is either revocable or irrevocable. So a lot of people say, who should control the trust and, why you shouldn't retain control over your trust as a settlor. What we're saying there is that if you are starting a trust and you're the settlor or the grantor of the trust, you should not also be the trustee. Essentially, you should appoint someone else the trustee, whether it's a spouse, a family member, a friend, a trusted advisor. And the reason is that when you do so, when you act as trustee, you're more susceptible to litigation on the trust. For example, fraudulent transfer claims. The creditors use this argument often to break through trusts to get to the debtor assets. So always a key thing you want to look at is who has control and who has ownership. The more control you have, the less protection. The less control you have, the more protection. So what are spendthrift trusts or spendthrift clauses? Anytime we draft a trust, we'll always make sure that they're spendthrift. And really, the spendthrift is really just another word for asset protection. So, for example, a trust without spendthrift language or without spendthrift clauses might say, at age 30, Johnny gets $100,000. Well, what happens if at age 30, Johnny's being sued? What happens if at age 30, Johnny's going through a divorce? So you want to always make sure that you do spendthrift trusts and put spendthrift clauses in all your trusts. So another way to write that might be, at age 30, the trustee should consider giving Johnny $100,000. However, if Johnny is being sued, going through a divorce, or is under any sort of duress, he should not receive the money. So the first example where he receives the money automatically has no spendthrift language. The second example where he might get the money, but only if he's not going through certain circumstances, has spendthrift language. And you always want to add the spendthrift language because you never know what somebody's going to be going through at the time. And you really want to protect the trust assets, even if it's to protect them from the beneficiary from himself. That person might have a drug or alcohol problem. So you might want to put a clause in there that says the trustee may consider giving Johnny $100,000 when he's 30, as long as he's sober and doesn't drink or use drugs. And again, these things are all customizable, so they're great tools. Irrevocable life insurance trusts are also referred to as ILITs, are great trusts to have to hold your life insurance. In fact, anybody who has a life insurance policy should really have an ILIT. An ILIT just stands for Irrevocable Life Insurance Trust, and it's set up like any other trust. There's the settlor or the grantor, the one who starts the trust. There's the trustee who owns the legal title to the assets in the trust. And then there's the beneficiaries, whoever benefits from the trust. And this is a irrevocable trust, hence why it's called ILIT, Irrevocable Life Insurance Trust. And here's the reason why it's so great. Let's forget the ILIT for a minute. Let's say you have an insurance policy on your life for $1 million, and you want to leave it to your son. Well, when you pass away, uh, whatever the estate tax is at that point, we don't know what it'll be. That $1 million will be included in your taxable estate. So if the estate tax is 50%, 50% will go to the government, and then the other 50% will go to your son. And your son takes that 50% income tax free. So life insurance is always income tax free, but if you own the policy, you're still going to pay half of it, or again, we don't know what the laws and rules and regulations will be at that time, but you're probably going to pay a big sum of money to the government in estate taxes. If you would have taken that same $1 million policy, and instead of you owning the policy, you have it owned by the the irrevocable life insurance trust, well, now when you die, that $1 million is not included in your estate, which means not only do you not pay income tax, you don't pay estate tax. So the full $1 million drops down to the son. So in that short example we gave, you saved literally $500,000. Now, if you have a $2 million insurance policy or a $5 million insurance policy or a $10 million insurance policy, the savings are only greater, but it's something you definitely want to consider. Now, again, this takes into consideration what the applicable tax rules and regulations and laws may be at the time of you die, and certainly no one can predict the future. But to be safe, I always recommend that clients, put their life insurance in an ILET. Now, I always get the question when I talk about ILETs, what if I have a life insurance policy now, but it's not in an ILET? Can you put them in an ILET? And the short answer is yes. You can transfer your current life insurance policies to the ILET. Now, there's things you have to do. You have to send out certain and specific letters. There's laws and rules and regulations you need to follow. But the main rule essentially is that if you live for 3 years after putting the life insurance in the ILET, the law looks at it as if the life insurance was always in the ILET. If you die within 3 years of putting the life insurance in the ILET, the law looks at it as if it was never in the ILET. And if you think about it, it makes common sense. The government doesn't want somebody who's 102, transferring his life insurance policy on his deathbed. So if you do the proactive planning, you're okay to go. But if you try and do things last minute, you're going to have a problem. So talking about domestic asset protection trusts and how they differ from regular trusts. Domestic asset protection trusts are essentially self-settled trusts. That means the person who starts the trust, the settlor or the grantor, are also the beneficiary. So essentially you're setting up a trust on behalf of yourself. And it used to be that this wasn't allowed. Then slowly different states would allow it. Now I think we're up to about 13 states plus or minus that allow these domestic asset protection trusts, or DAPTs, that are self-settled trusts. And essentially, I'm not a big fan of domestic asset protection trusts. Number one, there's longer statute of limitations. Number two, you have the possibility of litigation because it's a self-settled trust. You set it up on behalf of yourself. Only a few jurisdictions recognize the domestic asset protection trust. The potential choice of law issues in federal court, and the settlor and beneficiaries have to be in the DAPT state. So let me kind of break that down in English for you. There's about 13 states that allow this domestic asset protection trust, and essentially it means you're the settlor or the grantor, the one setting up the trust, and you're also the beneficiary. Well, what happens if you live in a state that does not allow the domestic asset protection trust? You have property in a second state, and then you set up the trust in a third state that does allow it. So you have 3 different states here. 2 that don't allow it, 1 that you live in, 1 that you have a piece of property in, and then the state that you set it up in allows it. Well, what state law is going to rule? Is it going to be the state that you set the trust up in that allows it? Is it going to be your state because it's your state of residency? Is it going to be the state that the real estate's in? It could be all 3. Judges could potentially have jurisdiction in all 3 of those states. And if 2 of the 3 states don't allow the trust, it could be broken. So that's number one why I don't like it. Number 2 is they're fairly new. They have not been around that long, so there's not that much testing that's been done. Now, I've seen a bunch of domestic asset protection trusts. I've seen case law where they've been broken through. So even the initial testing, I'm not a big fan in. But most importantly, there's a federal law which is called the Full Faith and Credit Clause. And the Full Faith and Credit Clause, which is a federal law, states that a judgment against you in one state is good in any other state, which means let's say somebody sues you and beats you and gets a judgment against you in Florida. Well, they don't have to sue you and beat you again in New York. That judgment in Florida should be good in New York as well. and that is a federal law. So if you have a domestic asset protection trust set up, even if you live in the same state that the trust is set up in, and you only have real estate and property in that state, and that state allows it, I think there's an argument to be made to try and remove the case to federal court, where the federal law would always trump state law, because federal law always trumps state law. And I would say the federal law states that a judgment in one state should be good in another. So I am not a big fan of the domestic asset protection trusts. You see them, quote-unquote, sold lately more and more by estate planning attorneys, not so much asset protection attorneys. But, something always to consider. So what can work? What type of trust can work? And an international trust is a very strong tool. The international trust is not for everybody, but there's also no black and white line of when you would use an international trust. I have clients who only have a few $100,000, and they want to use the international trust because it's their last few $100,000, or maybe they just want to sleep well at night. I have other clients who might have $1 million who don't use the international trust, and they might be in their mid to late 80s. They don't work, they don't drive, they don't own real estate. They literally have as little liability as humanly possible. So there's no black and white line of when you use it. I tell my clients if you have at least $500,000 in liquid assets, you should consider it. And the way the Asset Protection Trust works internationally is there's no U.S. control. So it's outside of the United States, which means the United States judges don't have jurisdiction over it. U.S. judgments are not recognized. So although you might have beaten someone in a lawsuit in the U.S., you'd have to go to wherever the country is that these international trusts are set up, and unfortunately that judgment more than likely will not be recognized. The creditor might have to relitigate the whole case. So let's say you set one of these trusts up in Nevis or the Cook Islands or Belize or Switzerland, wherever you do it, they might have to go to that jurisdiction and relitigate the entire case. There's going to be a totally different, recognized law, which means, in the United States, you might need 51% of the evidence, but in one of these countries, you might need 99.9, beyond a reasonable doubt. There's a short statute of limitations. In Florida, you might have 4 years to sue someone for a car accident. Well, depending on where you go internationally, you might have anywhere from 0 to 2 years. You're going to have to hire local counsel, and a lot of times there's no contingency fees. So instead of in the U.S. where you can get any attorney for free because they get a portion of the case if they win, you're going to have to pay hourly fees. You can argue that the creditor is going to have to post the bond for the defendant. You might argue that whoever's suing you is going to have to post hundreds of thousands of dollars because if they don't win the case, they have to pay your attorney's fees. There's very strict fraudulent transfer laws, and there's always something called a flee provision, which is something you might put in the 50 or 100 or 150-page trust agreement, which allows the trustee to relocate the assets at any time. So let's say you have one of these international asset protection trusts set up in, Nevis. Well, if someone's challenging it there, the trustee can move everything to the Cook Islands, and then the creditor is going to have to do everything all over again. This is the most protective entity in the world to protect post-tax liquid assets. Again, it's not for everybody, but if you have over $500,000 in liquid assets, you should certainly become educated about it.